are in listen-only mode.
Good afternoon. I'm Laura Rubenstein, a management-side labor and employment attorney, and I'm pleased to present to you an ongoing webinar series of interesting and educational topics related to employment law. Please note that this webinar has been approved for one HRCI credit. Confirmation numbers for participants will be emailed to you after the conclusion of this webinar. Please note that at any time you have a question, feel free to type it in to the bottom right-hand section of your screen, and time permitting, I will respond. Alternatively, if you include your email address, I can answer your questions offline. Before we begin, I want to talk to you about future lunch dates. The next one I have scheduled is for July 16th, and I'm co-presenting with my law partner, Eric Pelletier, on what to do once you've been sued. Eric and I will discuss navigating through the stages of an employment lawsuit, and you'll learn the importance of deadlines, establishing rapport with opposing counsel and the judge, expectations during discovery phases, and how to prepare for depositions and trial. If you have any ideas for topics you want to hear in the future, please feel free to email me because I'm always open to ideas and I want to present on topics that interest you. So today we're going to talk about mediation, whether to mediate or not to mediate, and what the benefits are to a workplace mediation program. Human resources professionals like yourselves know that employment disputes will always occur, but have you considered ways to limit your company's exposure and reduce legal fees and court costs? One way to do that is to implement a workplace mediation program. So what is mediation? Today we have 4 objectives. The first is, what is ADR? I won't share with you what that is. For those of you who don't know yet, I'll save it for the suspense. Different forms of ADR, why maybe you should choose mediation, and when maybe you shouldn't choose mediation, issues that can be resolved through mediation, and actual steps in the mediation process. So first, what is ADR? ADR stands for Alternate Dispute Resolution. And ADR includes dispute resolution processes and techniques that act as a means for disagreeing parties to come to an agreement short of litigation. It's a collective term for the way the parties can settle disputes with or without the help of a third party. ADR has gained widespread acceptance among both the general public and the legal profession in recent years. In fact, many courts now require parties to resort to some type of ADR process, which is usually mediation, before permitting the parties' cases to be tried before either a judge or a jury. The rising popularity of ADR can be explained by the increasing caseload of traditional courts, the perception that ADR imposes fewer costs than litigation, a preference for confidentiality between the parties, and the desire of some parties to have greater control over the selection of the individual or individuals who will decide their dispute. Of the forms of ADR, mediation tends to be the most popular, and we'll see why that is in a moment. I do also want to note, because I saw the attendee list of the folks who are listening in today, that we have amongst us a doctor, Dr. Michael Haidt, and Dr. Haidt, I had the pleasure of presenting a webinar with him last year, which is archived on Afik Herman's website. But I wanted to note why I'm bringing him up and giving him kind of a shout out is that Dr. Haidt is a psychologist, and an alternative to alternate dispute resolution if you have maybe a difficult employee, and mediation or any kind of other alternative dispute resolution is not appropriate, perhaps having that employee seek counseling to improve performance, improve attitude, improve behavior is another option. So let's start with the first form of ADR, which is negotiation. Negotiation is a dialogue between 2 or more people or parties intended to reach an understanding, resolve their points of difference, or gain advantage in outcome of dialogue to produce an agreement upon courses of action, to bargain for individual or collective advantage, to craft outcomes to satisfy various interests of 2 people or parties involved in the negotiation process. Negotiation is where each party involved in the negotiating tries to gain an advantage for him or herself by the end of the process. Negotiation is intended to aim at compromise. However, the process tends to be adversarial and not collaborative. So think about you and your significant other, you and your parents, you and your siblings. You're constantly negotiating. This morning I was negotiating with my 4-year-old who wanted to watch a video before school, yet I needed him to get dressed. So we came to a compromise where after he got dressed, he was able to have his breakfast while eating his video. But he wanted one thing, I wanted the other thing. Fortunately, we were able to compromise this morning. But in compromising, we engaged in that negotiation. If you do this, I will do this. Neither of us had to really retract from our stance, but that is generally what a negotiation is. Another form of ADR is arbitration. Now, arbitration is a technique for the resolution of disputes outside the courts, where the parties to a dispute refer it to one or more persons called arbitrators, arbiters, or before an arbitral tribunal, by whose decision they agree to be bound. It is a resolution technique in which a third party reviews the evidence in the case and imposes a decision that is legally binding for both sides, and it's also enforceable. Think of someone who is a judge without sitting in a black robe on the bench. Arbitration is often used for the resolution of commercial disputes, consumer and employment matters, typically in a unionized environment, where arbitration may be mandated by the terms of a collective bargaining agreement, an employment contract, or a commercial contract. So for example, if you build a home, if you purchase a vehicle, if you purchase tickets for travel or for entertainment, there may be arbitration clauses contained in the fine print of the agreement, or say on the back of your ticket if you have a dispute with the entity. Now, arbitration can be either voluntary or mandatory, although mandatory arbitration can only come from a statute or from a contract that is voluntarily entered into, where the parties agree to hold all existing or future disputes subject to arbitration without necessarily knowing specifically what disputes will ever occur, and can either be binding or non-binding. So non-binding arbitration is similar to mediation in that a decision cannot be imposed on the parties. However, the principal distinction is that whereas a mediator will try to help the parties find a common ground on which to compromise, the arbitrator remains totally removed from the settlement process and will only give a determination of liability and, if appropriate, an indication of the quantum of damages payable. So there are limited rights of review and appeal of arbitration awards. So if you, I just recently had an arbitration that I handled, and the facts were not favorable for my client. It was a unionized environment, and the arbitrator ruled that the employee would be reinstated with full back pay. That was not an appealable decision. So finally, what is mediation? Mediation is a confidential, usually voluntary process of shared decision-making in which one or more impartial persons, mediators, assist people, companies, and organizations in conflict to work toward a variety of goals. Now, historically, the practice of mediation developed in ancient Greece, and some cultures regarded the mediator as a sacred figure worthy of particular respect, and the role partly overlapped with that of a traditional wise man or a tribal chief. Members of many peaceful communities frequently brought disputes before local leaders or wise men or wise women to resolve local conflicts. So today, mediation is a way to resolve disputes without filing a formal complaint or a lawsuit. It provides a private forum in which the disputing parties can discuss the dispute, feel they're being heard, which is very important, especially if you are the person bringing or the party bringing the claim before a mediator. The parties can also gain insight from each other, understand the perspectives of the other party, and work together to explore and develop possible ways toward resolving disputes. Mediation can be used between coworkers who aren't getting along, when there is a perception of bullying or misperception or poor communication. So before we go to the next slide, I thought we would I'd ask all of you listeners out there a question. If you've ever participated in a negotiation, and I'm not saying negotiating with a friend or a spouse, but in the workplace or in another kind of environment. Have you ever participated in a negotiation, arbitration, mediation, or none of the above? And we're getting our responses in now. Looks like about and you can answer more than one, obviously. So we'll stop the poll now. So about 30% of you have been involved in a negotiation. 30% of you have been involved in an arbitration. 56% of you have been involved in a mediation, and then another 30% have not been involved in any. So hopefully we'll all learn something today about the mediation process. And again, mediation is used for litigants who have filed a charge of discrimination. Mediation is a voluntary form of ADR that parties can engage in front of a neutral mediator at the EEOC, at the Maryland Commission on Human Relations, at any state or other local agency, for example, the Howard County Office of Human Rights, Baltimore City Civil Rights Office, etc. So there are many reasons to choose mediation in the workplace, and here are just a few. The first is recognition and understanding. When employees feel they're being heard and have the opportunity to hear and understand the other party's point of view, the chance for an amicable resolution is heightened. Another reason is self-empowerment. The workplace is an environment in which employees feel they're normally being told what to do. So mediation offers employees the opportunity to have input in the decision on how to resolve a situation. Next, timeliness and speed. Mediation can take place pretty quickly, usually within a week or so, on the short end of it. Otherwise, it might take a few months to schedule if you're looking for a particular mediator. And within a short period of time. So a resolution can be kind of hammered out between parties after just a couple hours. In contrast, a formal complaint filed with a regulatory agency or a court can take years to resolve. And in some experiences that I've had, they might even fall into a black hole and you never see them again. Another reason why, it's cost effective. Mediation is cost effective not only financially, but also in human capital and time. A mediator's fees are a fraction of the cost of attorney's fees incurred during protracted litigation. Next, it's confidential. Once a lawsuit's filed, it becomes a matter of public record, while mediations, by their very nature and contract, are confidential, regardless if a mediation takes place prior to or after a lawsuit has been filed. Typically, parties should agree at the outset whether what is discussed at the mediation will remain confidential to outsiders or whether it can be used in future litigation if the matter is not resolved. And finally, and most importantly, is the flexibility of the mediation agreement. Studies have shown that when disputing parties voluntarily enter into a mediation agreement, they're far more likely to adhere to the terms since they were involved in drafting and designing the resolution rather than when a judgment is imposed by a court or a regulatory agency. And that's what I really enjoy when I mediate. I was recently in Delaware last week with a client, and we were involved in trying to settle a discrimination charge. And what I really enjoyed is coming up with many creative ways in order to have the employee, number one, return to work, number two, resolve her charge, and number three, feel good about the process and have everyone feel good about the process. And sometimes you throw out an idea, they don't really like the idea, but the other party who is maybe less experienced in mediation, they don't know that, hey, the world is your oyster. You can come up with all kinds of options and throw them out there. So, in this case, it doesn't always have to involve money. I was able to get it resolved by just extending this employee's leave of absence and not having to pay any additional money or funds or benefits to her, and it really was a win-win. So I was happy about that. And again, my first suggestion didn't work out. She rejected it. Second suggestion, she kind of, when it was presented to her, she kind of said, maybe. And then the third suggestion we came up with to resolve it in the mediation, she liked. So we were able to resolve it, which was very helpful. So let's talk about some different workplace scenarios that could benefit from mediation. First, problems between employees. Even the simplest of problems between employees, if left unresolved, can fester and grow into much larger issues that not only negatively affect the employees involved, but obviously impact others around them. And you all know what happens. You hear the workplace gossip. It takes away from productivity. People start choosing sides. It gets very ugly. So employee disputes are certainly one avenue where mediation can be used to resolve their disputes. And again, it can be confidential, it's impartial, non-judgmental, and it serves to empower the employees to positively change their own workplace interactions. And if you offer mediation in your handbook, or even if you don't, an employee or a supervisor should be able to suggest that a mediation be held when problems are identified between two or more employees, such as, for example, when an employee, not a supervisor, is constantly delaying work or patronizing his or her workmates. That might be a good opportunity to suggest that employees engage in mediation. Secondly, performance issues. Employee performance can deteriorate for an array of reasons, including communication style, personal interactions, misperceptions, which I find usually is the case, misunderstandings regarding roles and responsibilities, etc. Mediation can offer an alternative and likely more productive forum in which to discuss these difficult issues outside of the standard performance review process. For example, say you have a superstar salesperson who's suddenly experiencing a decline in sales. There could be an issue between her and a team member who works as the inside administrator who feels like maybe he's being dumped on or taken advantage of for providing support to this superstar. Perhaps he's getting no recognition even though he's processing more orders and has to take more customer calls because he's assigned to the superstar salesperson. Again, that could just be a misunderstanding, miscommunication. Maybe the superstar isn't, thanking him enough. Maybe, the communication is short and curt and, could be longer with more explanation. Again, that can be resolved by having a neutral mediator sit down with the two parties and just allow them an opportunity to talk about what their concerns are. Next, harassment complaints. Utilizing mediation as the first step in dealing with harassment complaints can be helpful, especially if the complaint is based on a misperception or misunderstanding of what is acceptable workplace behavior. Mediation can serve to open communication between the parties, clarify what is acceptable workplace behavior and what is not, and foster a healthier understanding between coworkers. For example, oftentimes you as HR folks will get complaints that, oh, he's harassing me, she's harassing me, I didn't like what she said, I'm being bullied. Or for example, you have a loud talker or someone who thinks that all of his jokes that are hilarious when no one else thinks they are. And you do your investigation and you usually determine, okay, well, that's not the definition of what harassment is, that's not the definition of discrimination, but how do we get these two parties to talk, or how do we get this resolved going forward? And finally, termination. Now, a termination is always a difficult situation for the employee in question. It's difficult for the employer, and it's also difficult for other employees. Mediation can help the employee feel they fully shared their feelings and concerns regarding the termination in a circumstance in which the power lies ultimately in the employer. And again, mediation can offer an opportunity for a peaceful parting and allay the employer's worries of potential litigation. Note, I would never recommend mediation where the termination is on the basis of violence or threatened violence, a theft, or gross insubordination. But again, mediation when you're terminating someone can be kind of an alternate to that the survey, the exit survey you give employees. If there is still maybe some unresolved disputes you believe the employee may feel when they're being terminated, mediation could be an option for that. So next, there are generally 6 steps in the mediation process. The first step, sorry, I had a poll. My assistant here is reminding me I had a poll for you. And let me ask you that. So do you think you would use mediation as a tool to resolve issues, A, between employee issues with performance issues, harassment complaints, termination meetings? Thanks for the reminder. And you're answering now. Let's see, about 60% of you have voted so far, 70%. Excuse me. Okay, so we'll stop. Okay, so great. So about 90% of you said that you would recommend mediation when you had problems between employees. 40% said you would recommend it with employees who were having performance issues. 61% said you would use it with regard to harassment complaints. And about 30% said during termination meetings. So there is certainly some value in termination meetings, but again, the circumstance would have to be right. So thank you. So let's move on to talk about the 6 steps in the mediation process. And so starting with step 1, the opening statement. During the opening statement part of the process, the mediator really kind of takes control and explains his or her role and what the rest of the process will look like. When you don't have a mediator who does that, it's a problem, okay? The mediator should be affirming that mediation is a voluntary, confidential, and neutral process. The mediator should be defining and obtaining agreement that the parties will follow certain ground rules during the mediation. So, for example, no interrupting or name calling, the need for all parties to listen to each other, take notes, etc. And it also reduces, the mediator should reduce the ground rules into a written document called an agreement to mediate. The mediator will also explain what a caucus is and when and how a caucus might be utilized in furthering the mediation process. And we're going to talk about caucus as I think it's step 5. So also during the mediator's opening statement and throughout the mediation process, the mediator affirms that the mediation is the parties' process and that the parties will be designing the resolution. The mediator explains that the role of her is to help the parties identify problems and that the mediator is not there to represent or take sides for one or more of the parties or impose a decision. Really, the mediator's role is to be a facilitator and to help the parties formulate their own resolution of the dispute. One of the most important tenets of mediation is confidentiality. And the mediator should explain that what happens in mediation stays in mediation, kind of like Las Vegas, right? And cannot be used outside of the mediation process. In fact, most mediators will require parties to sign a confidentiality agreement prior to the start of the mediation. And the mediators at the end of the mediation should, and usually do, destroy their own notes at the conclusion, and they cannot be called as witnesses. If the issue does not resolve at the mediation, mediators cannot be witnesses for either side in future litigation. So step 2 in the mediation is identifying the problem. The mediator and the parties will agree upon who will speak first, which is usually the complaining party, and each party will be given the opportunity to explain the nature of the dispute, how the dispute has affected them or upset them, interfered with their work performance, etc. So hearing the other party's point of view can be difficult if you are sitting across from them patiently, neutrally with your poker face on, listening to the woes and watching the tears come down. But it's very important that you as the employer sit there very neutrally and patiently and listen and take notes so you can respond when it's your turn to respond. But again, oftentimes the charging party or the complainant, the initiating party who brings this mediation will find that this opportunity for him or her to go first in the mediation process and explain the tales of woe and how they have been treated so poorly and it's been so unfair and coming to work has been so difficult and working for this tyrant is, awful, that will be such a cathartic experience for this employee that they already will feel better about the process if someone else has heard them, even though, again, the mediator can't make the decision, but it will be very cathartic for that employee. Okay, so step 3 is identifying the issues and setting the agenda. The mediator's role is to help the parties identify the issues and the core problems surrounding the dispute, also to frame the issues and gain consensus on what the parties want and need to resolve, and help set the agenda for the mediation. The parties together draft the agenda, which creates an anchor for the mediation and helps focus the parties on the issues that are important to resolving the dispute. Bringing up my example last week when I was in Delaware resolving this EEOC charge, fortunately the mediator I thought was very good at reining in the employee who was talking about so many other extraneous matters that were completely outside of the charge of discrimination, had nothing to do with her allegations. And then the employee started bringing up complaints that other coworkers had and that they had all talked about. And the mediator just kind of put her hand up and said, okay, let's refocus. We're here to talk about this issue right here before us. And it was nice to have a mediator who was involved and was active and was listening, because when one of the parties went kind of outside the scope of what we were talking about, what our agenda was, the mediator kind of reined her back in, and I found that to be very, very helpful. Next is finding solutions. Step by step, the parties should work together through the agenda items and brainstorm solutions. Throughout the process, the parties work to define what each party would like the other party to do or not do differently in the future. And sometimes brainstorming, we're going to get to the next step. We'll go to step 5, which is caucus. So caucuses are confidential breakout sessions between the mediator and one of the parties. And also, caucuses can really be, say you're being represented by an attorney, an opportunity for your attorney and you, the employer, to speak together to say, okay, this isn't working, or I can tell you needed a break in there and you needed time to speak with me without the mediator present or without the opposing party present. So what's on your mind? What's going on? So caucuses are not just breakout sessions between the mediator and one of the parties, but also an opportunity for the employee to have a little respite or to vent to your own attorney. Now, caucuses are confidential, and they're individual breakout sessions. Caucusing provides the opportunity for a party to share things that they are not otherwise ready to share with the opposing party. Maybe disclose to the mediator facts that they weren't comfortable disclosing with the other party there. Also maybe facts that are hurtful to their own side. You'd have to think strategically what the point of disclosing that to the mediator would be, although sometimes clients just again, to be cathartic and share everything with the mediator. But as the attorney, or in your case, if you're representing your company, you need to determine what is appropriate and what is not appropriate to share with the mediator. Okay, and finally, step 6 is the agreement. The agreement should absolutely be written down and should be signed before you leave the mediation for the day. It should be written down in plain English rather than legalese, and it should detail the facts and objectives, including the nature of the dispute. It will detail each point negotiated and the promise or the condition related to that point. It should be fair, it should be balanced, and it should be reviewed by each party before it's signed. And then most of all, it should be signed by the parties there before you leave, and each party should have a copy of it. So let's talk about who is an effective workplace mediator and how do you choose the right mediator. The most effective workplace mediator is a certified mediator who has completed mediation training through a recognized mediation training program. Certified mediators are trained in the essential skills of impartiality and neutrality and have a thorough understanding of the mediation process. Options include choosing someone internally in your company who is or is willing to become a certified mediator, or you can seek an expert externally. Most importantly, remember that when you're selecting a mediator, select someone who's experienced in the field in which you're mediating. You don't want to be going through a divorce and have a construction law mediator there. Simultaneously, you don't want to be dealing with an employment dispute and have, a divorce mediator there. You need someone who's experienced in the area of law or experienced in the area that you're addressing, because that mediator, who usually is a lawyer, or sometimes not. I mean, a lot of time I went through mediation training, and I think there were maybe 2 paralegals. They did have some law background, and they were getting their mediation certification. But that's really one of the biggest mistakes you can make, is hiring a mediator or engaging a mediator who is not experienced in your area. And let me give you some examples about a poor mediator. I'm going to read, or to summarize, an article from the Maryland Bar Journal from March 2012, and it's titled "Adapting Mediation to What Users Want." And they interviewed an attorney, a corporate attorney, who gave a couple examples of when the wrong mediator was chosen. And she says, here's another example. One of our drivers for our company got into a bad accident involving one of our tanker trucks. We were at fault, so the only question was one of damages. Well, the court assigned us to a mediator who was a retired judge from another county. He listened to both sides and then announced in front of all of us what he thought the value of the case was and what we should pay. Well, it stopped the mediation in its tracks. We thought he hadn't listened to our points and was dead wrong, but we still had to go through an expensive trial because the other side wouldn't budge after this mediator's evaluation of how much the case was worth. And then she goes on to say that type of style was all wrong and cost my company a lot of wasted time and money. Another example she gives is, she says, my company was involved in a big environmental dispute with the EPA and the State Department of the Environment over an underground storage tank that was allegedly leaking. We were willing to accept some responsibility, but we had only owned the gas station for less than a year, and the tank was 40 years old. We got a mediator who was very pleasant. She constantly asked permission from us about the process and dutifully carried messages back and forth, but she was totally ignorant of allocation issues and couldn't begin to help sort out how to construct a fair model of sharing liability among the parties. She just didn't understand the legal and factual basis for conducting an allocation of liability. What we needed was someone with the appropriate background who, at the right time, would have prodded us toward a fair settlement, even if that meant putting out her own recommendation as a straw man for us to bargain against. All this mediator wanted to do was facilitate our negotiations. We got along with the other side just fine. We didn't need a facilitator. So, mediators have to be pretty flexible, and it helps to know exactly what your, what clients need or what the parties need. So, when a mediator's style doesn't fit, that can be a problem. So if you are looking to select a mediator, you may want to already have a kind of approved panel of experienced mediators that you would select from. Or, it's always good to interview. You can get some gossip about mediators and their experience and the decisions, and you can always talk to parties who have used these different mediators to find out, hey, what was she like? Was she helpful? Is she experienced in this area that we're dealing with? Always do your homework on mediators before you engage one. Again, someone who's too outspoken or involved in the process, or too soft-spoken, and the parties are seeking more input or help, particularly when it's a first mediation, can be an issue. So make sure you're able to identify your own style that you're seeking, and then do your due diligence about finding out this mediator's background. So these days, clients can be very demanding, and they're demanding a different type of mediation. So one where mediators are more engaged in the process, and they want mediators to give their analysis of the case, including strengths and weaknesses, recommend settlements, predict the likeliness of jury awards or court rulings on the issues, and to apply pressure on the parties to settle. So sometimes, in the first example I talked about, where the retired judge in the lawsuit suggested, oh, this is what I think, this is my value of the case, and this is what I think you should pay. Sometimes, parties want to hear that, and sometimes they don't. It's one case if the mediator in a private caucus says that to the employer. Says, hey, if I were the judge, this is what I think. But that mediator should not make that statement in a private caucus with the charging party or with the individual employee, and certainly should not make that statement in the group session amongst everyone. So you can and should recommend mediation for internal businesses or maybe leadership disputes, particularly involving family businesses. I don't know how many of you work in family businesses or work at a family business, but having mediation can be very important when siblings don't get along, when husband and wife don't get along, when brothers own the business, when other family members generationally own the business. And mediation might come in handy when, say, for example, siblings feel like others aren't pulling their weight, parents who might be reluctant to transition power to a firstborn who lacks leadership skills, or maybe there's a dislike of a family member's spouse, or maybe, a sister has been harboring resentment over unrelated issues from years past. Mediation can peel away emotional overlays or false assumptions and get to the heart of the issues to clear the air and to craft a solution that works for everyone. If the parties opt for litigation rather than mediation, remember that litigation is limited to traditional remedies available under the law. So for example, the law might say in a business dispute, you might have a contract. It says Tim, is purchasing Laura's company. Tim is purchasing the company for $50 million. In exchange for that, in exchange for that, Laura will continue on as an employee for the next 5 years. If there is a business dispute and Tim and I take that to court and Tim wins, then, the judge will basically impose the fact that, okay, Tim, you didn't pay all the money, or Laura, you didn't work in accordance with your contract, so this is, A, B, and C. The judge is really limited with what he can impose based on contract or based on statute. However, if Tim and I decided we wanted to mediate, it's just endless what type of options there are out there for us to come to our own resolution. And again, it will preserve the workplace, it will preserve our working relationship, it will preserve the business and the future of the business, as opposed to being so adversarial, getting lawyers involved, paying lots of fees, getting everyone riled up. If Tim and I wanted to engage in mediation, we would be able to do that privately. So let me wrap up here, and then I'll be able to get to a couple different questions. I hope you've learned about the benefits of a mediation program at your workplace and may consider adding mediation to your employment toolkit. Whether you revise your employee handbook and you add this as a possible policy. But again, as I mentioned earlier, even if you don't have this as a written policy, you can always recommend that parties engage in mediation. It should be voluntary, which is where parties tend to have the most buy-in and where resolution is usually found, as opposed to forcing a party to engage in mediation. I know by experience that the DC Office of Human Rights has a mandatory mediation program, and I have one particular client that has a lot of employees in DC, and every time they get a charge filed at the DC Office of Human Rights, we kind of groan to each other over the phone and say, oh, great, we have to drive to DC again for this mandatory mediation. It's a frivolous charge. We're not going to offer anything. We're not going to reinstate. It's just going to be a waste of everyone's time. That's unfortunate. Whatever reason they came up with it, that should be the policy. That's their policy. So we're forced to go. And sometimes it's helpful because, hey, you know what, maybe it's a current employee, we want to preserve the relationship. But mandatory mediation that's imposed upon you when really, you have no interest in resolving the matter and it's completely meritless it tends to be difficult, and you'll find one party is usually pretty disgruntled. I also wanted to let you know that we have several attorneys here at the firm, including myself, who are certified mediators with experience in helping clients resolve disputes. And we've all handled a variety of cases, including mediating EEOC charges, contract disputes, business disputes, family disputes, estate disputes, state or local discrimination and harassment claims, and even resolved with our clients issues they've had with their own employees, kind of being that facilitator for that conversation. So let me go to some of your questions here. I thank you all for participating. Looks like we'll end a little early today after I get to some of these questions. So let me see. Okay, so a comment from Dr. Height. Thanks for the shout out at the beginning of the presentation. I totally agree that voluntary mediation is often the most humane method of resolving conflict. Can you speak to how you deal with the power differential that is often present in dispute resolution in employment settings? Yeah, and thanks for making that comment and asking that question. I think employees, and I think I mentioned, so I'm not sure what time you wrote your question, Dr. Height. But what I mentioned is that often employees come to the table. They can be represented or not represented if it's voluntary. Oftentimes, believe it or not, as an attorney representing an employer, I usually like when there's another attorney on the other side. That means that the attorney has counseled her client about what to expect in mediation, and they've hopefully come up with some preconceived suggestions or ideas for resolution, and they've done their homework. So I do prefer when clients are represented on the other side. And again, just having the employee sit on one side of the table with the employer on the other and sitting in this zone of neutrality and allowing the employee to get off her chest everything that's been bothering her. And, sometimes I've sat through and it's been very difficult not to roll my eyes, but you just patiently sit there as the employer with your poker face, you take notes, you remain professional, you don't make the ugh and ah noises, or you hear people make those when they disagree with statements that are being said, and then that alone really helps the employee feel better about the whole process, that they were heard, they had the opportunity. Finally, someone listened to me. Finally, someone listened to me. And even if that person listening is the mediator, it makes that employee feel so much better. And that's how that is one way to deal with the power differential. Otherwise, honestly, it's not. It's just there. Another way to deal with it is perhaps having someone who is not the say the harasser or the bully sitting at the table. So having a company representative other than someone who is the difficult employee, so they're not hashing it out face to face and raising their voices at each other and continuing to accuse each other. I mean, this isn't like a boxing ring. Mediation is supposed to be civil, and it should be civil. And if the mediator is doing her job correctly, it's an opportunity for the parties to listen civilly, discuss it, and again, there's less confrontation when you have a company representative other than the harasser or the bully who's sitting across the table. Okay, so another question is, can ADR be made mandatory as a condition of employment? Can it be mandated in the employee handbook? And the answer to both of those questions is yes. ADR can be made mandatory as a condition of employment. And can it be mandated in the employee handbook? Yes, it can. You know, there's language, Mike, that I could probably give you and suggest to you that you know, perhaps certain situations should not be mediated, and you can have that exception carved out. You know, by using the word may versus shall is one example of how we can differentiate, because there are times, as I mentioned, so if you're terminating an employee or investigating an employee, or there's a dispute between employees involving theft or violence or gross insubordination, those are really not situations that you want to mediate or really waste your time and resources on, when employees are just are too difficult, beyond rehabilitation, too upset, and the situation's too volatile. Those are times when you don't want to worry about salvaging the employment relationship, and you don't want to engage in mediation. So I hope I've answered all of your questions. I thank you all for your participation today, and I look forward to having you join me for my next webinar, which is scheduled for July 16th. In the meantime, if you have any questions, feel free to email me or to call me. And again, if you have any suggestions for future topics for this webinar presentation, please let me know, because I'll be happy to address them. Thank you.